Here's where we're going to start. Not with a slow build-up, not with background. We're starting in the middle of the fight because that's where most families find us anyway. It's 11 months after their mother's funeral. 3 siblings, call them David, Karen, and Michael, are sitting across from an estate attorney, not together. David is on one side of a conference table. Karen and Michael are on the other. There's a court reporter in the corner. The estate is frozen. The house can't be sold. The bank accounts are locked. Nobody has received a dollar. And the legal bills, just the legal bills so far, have eaten $42,000 out of an estate that was supposed to be split 3 ways. How did they get here? Their mother wasn't wealthy. She had a paid-off house worth about $310,000, a modest savings account, and a strong wish that her 3 children would take care of each other after she was gone. She never imagined this room. This video is about that room, and the 5 decisions, made years, sometimes just months earlier, that put them in it, or kept them out. Because here's the thing this channel is built on. The families who end up in that room almost always got there through a series of completely preventable steps. Not through malice usually, through neglect, through avoidance, through the very human belief that love is enough and that the hard conversations can wait. I'm going to show you exactly where each decision point was. I'm going to show you what the families who avoided this conflict did differently, and I'm going to give you a concrete plan for protecting your own family, not someday but this week. I'm not your attorney. I'm not your financial advisor. What I am is someone who has spent a lot of time studying how families lose financially and relationally when a parent ages without a plan. Everything I tell you today is general education. Your family's situation will have specifics that require a certified elder law attorney, and I'll remind you of that throughout. Let's go back to the beginning. Let's find the first fork in the road. Fork 1. The moment mom needed help. It started the way it starts in most families. Gradually, then suddenly. Their mother, Ruth, and I'm using a composite here, the names and details are changed. Ruth started needing help when she was 79. Small things at first. Forgetting appointments, letting the mail pile up, a fall in the bathroom that wasn't serious but scared everyone. David lived 12 minutes away. Karen lived 45 minutes away. Michael lived in another state, 3 time zones west. Guess who became the caregiver? David started taking Ruth to her doctor's appointments. Then he started managing her bills. Then, when she had a second fall and couldn't drive, he started doing her grocery shopping twice a week. Over 18 months, David estimates he was putting in 15 to 20 hours a week. He kept no log. There was no agreement. He wasn't paid. He did it because she was his mother. Karen visited on holidays and called on Sundays. Michael called less often. Neither of them tracked what David was doing. David didn't ask them to. And when Ruth occasionally said things like, "Don't worry, David, I'll take care of you," David believed her, the way you believe your mother when she says something with love in her voice. There are 53 million Americans in a situation like David's right now, providing unpaid care to a family member. The total value of that unpaid care across the country is estimated at $600 billion a year, and almost none of those caregivers have a written agreement that would hold up legally. That is fork 1, and almost every family in that conference room missed it. What does taking fork 1 correctly look like? It looks like a conversation, early while the parent is mentally capable, about compensation. Not because love should be transactional, because intentions should be enforceable. A certified elder law attorney can help set up what's called a personal care agreement, sometimes called a caregiver contract or personal services contract. It's a written document that specifies what care will be provided, at what hours, at what rate of pay. The rate needs to reflect what a private caregiver in your area would charge. In 2026, the national median for in-home care runs around $34 an hour. Too high and Medicaid may later treat the payments as gifts. Too low and it doesn't reflect the actual sacrifice. The agreement needs to be signed before care begins, not after. It cannot be retroactive. If David had this document, if Ruth had been paying him a fair market rate for 18 months of documented care, 2 things would have been different. First, David would have had a legal record of his contribution. Second, Karen and Michael would have known about the arrangement. Surprises are fuel for conflict. Documentation is a fire extinguisher. David had neither. So when Ruth died, and the will divided everything equally 3 ways, David felt he had been robbed of something his mother had promised him. Karen and Michael felt he was trying to take more than his share. Everyone believed they were right. Everyone was telling the truth as they understood it. That is the cruelest kind of family fight. Fork 2. The will that never got updated. Ruth had a will. She'd made it when her husband was still alive, 22 years earlier. It divided everything equally among the 3 children. She'd always meant to update it. You know where this is going. After 18 months of watching David sacrifice his evenings and weekends, Ruth had told her sister she wanted David to have the house. She had mentioned it to her pastor. She had said it to David directly, more than once. What she had never done was call her attorney. Intentions are not legally binding. A conversation is not a codicil. When Ruth died, the 22-year-old will was the controlling document. It said equal thirds. The law followed the document, not the wish. Here's what Ruth could have done. At any point while she still had mental capacity, meaning before any dementia diagnosis that might complicate the question of testamentary capacity, she could have met with an estate attorney and updated her will to reflect her actual wishes. She could have left David a larger share, or the house specifically, or structured a trust that compensated him for caregiving. An attorney meeting with her privately, confirming her capacity and recording her stated reasoning would have created a record that would be very difficult for disgruntled siblings to challenge in court. The key phrase is meeting with her privately. When a parent updates an estate plan with a caregiver child present or appears to be under that child's influence, it creates legal vulnerability. The other children can argue undue influence. The meeting needs to happen independently, with the parents speaking in their own voice. Ruth's will was the same document she'd signed under a different president. That is, Fork 2. Updating estate documents to reflect the current reality before the crisis, not after. How often should a will or trust be reviewed? At minimum, after any major life change, a death in the family, a diagnosis, a significant change in assets, a child moving across the country. Many CELA attorneys recommend a review every 3 to 5 years regardless. Fork 3. The silence about the plan. Let's talk about the silence. Even if Ruth had updated her will to leave David more, that decision would have landed better, might have survived without litigation if she had told her children about it while she was alive. The research on this is consistent. When a parent can speak for themselves, explain their reasoning, and answer questions directly, the likelihood of a sibling dispute after death drops significantly. What makes an unequal distribution feel like theft to the siblings who received less is usually not the inequity itself, it's the surprise. It's the feeling that something was done in secret. It's the story that writes itself in the absence of information. He must have manipulated her. She must have pressured him. How could we not have known? A parent who says, while alive, David did more than his share for 3 years, and I want the estate to reflect that. That parent is delivering a verdict with their own voice. Karen and Michael can disagree. They can grieve it. They can even be angry. But it is much harder to turn that into a legal claim of undue influence when the parent said it openly, in front of family, or in a documented conversation. This conversation does not need to reveal every dollar in every account. What it needs to communicate is 3 things. This is intentional, these are my own wishes, and here is the reason. The right time to have that conversation, by the way, is now. Not after the diagnosis, not after the fall. Now. Fork 4. When the money started to move, here is where the fire gets oxygen. After Ruth's second fall, David helped her move some money from a savings account to her checking account to cover a repair on the house's furnace. He had been added as a joint account holder. His mother had suggested it so he could pay her bills. He moved the money himself without calling Karen or Michael because the furnace needed to be fixed and he was the one who was there. Karen found out 3 months later when she was going through her mother's mail during a visit. She didn't say anything to David. She started keeping a mental list. When Ruth died, Karen and Michael hired their own attorney. The first question that attorney asked was, "Did your brother ever have access to your mother's accounts?" Karen had receipts. I want to be very careful here because there are 2 versions of this story and both of them are true in different families. In some families, the sibling with account access is genuinely protecting a vulnerable parent. In other families, financial exploitation does happen, and it is one of the most underreported forms of elder abuse in the country. What protects the honest caregiver is the same thing that catches the dishonest one: documentation and transparency. If David had sent Karen and Michael a brief monthly email, "This month I paid the furnace repair, $847, the gas bill, $112, and mom's prescriptions, $63, total $1,022 from her checking account, the paper trail would have been boring instead of suspicious. He would have had proof. They would have had visibility. The mental list never gets started if there are no surprises. If you are the caregiver sibling managing a parent's finances, transparency is not optional. It is your legal protection. If you have power of attorney for your parent, you have a fiduciary duty to manage their assets in their interest. Keep clear records, and in most states provide an accounting if another interested party requests one. Failing to keep records does not just create family conflict. It can create legal exposure. And if you suspect, not assume but genuinely suspect, that a sibling is misusing a parent's finances, that is a matter for Adult Protective Services and a CELA, not a group text. Fork 5. The conversation nobody could have. This is the one that hurts most to talk about because there is no fix for it, but understanding it is part of getting out from under it. By the time Ruth was in her final months, the relationship between David and his siblings was already strained. Karen was visiting more, forming her own assessment of their mother's condition and her brother's role. Michael was calling lawyers. Ruth, exhausted, medicated, and trying to hold her family together, could feel the tension every time two of her children were in the same room. She never got to have the conversation that might have cleared it, not because nobody wanted to have it, but because nobody had the skills for it, and there was no structure for it. Families in this situation have options that most of them don't know about. The first is elder mediation, a mediator specifically trained in family caregiving and estate disputes who can facilitate a structured conversation while the parent is still alive and capable of participating. This is not therapy. It is not arbitration. It is a guided process that puts the parent's stated wishes at the center, with a neutral third party helping siblings hear each other instead of just reacting. The second option, after death, is estate mediation. Litigation is expensive. It is adversarial. It destroys relationships and frequently produces outcomes nobody wanted. Estate mediation is cheaper, faster, and gives both sides more control over the outcome. Attorneys sometimes refer clients to it. Sometimes families have to request it themselves. David, Karen, and Michael did not use either. They went to court, and by the time they settled, 11 months in, $42,000 in legal fees, a house that had sat empty and depreciating the whole time, nobody won. David got a slightly larger share. Karen and Michael got what the will said. Their mother's savings, which she had carefully preserved for 40 years, were largely consumed by attorneys who had never met her. The 5 forks, reviewed. Let's come out of the story and into the plan. Because here's what I want you to leave with. This is not inevitable. The outcome David, Karen, and Michael reached is common. It is not required. The 5 decision points and what you can do about each. Fork 1 is the caregiver agreement. If one sibling is providing substantially more care than others, that contribution should be formalized in a written personal care agreement, signed before care begins at a market rate, with a daily log of services. This creates legal proof of the arrangement and requires a conversation with the other siblings so there are no surprises later. Work with a CELA to make sure the agreement is Medicaid compliant. An improperly structured contract can create look-back problems if the parent later needs nursing home care. Fork 2 is the updated estate plan, a will or trust that reflects the parent's actual current wishes, including any intent to compensate a caregiving child, is the document the law will follow. It needs to exist, it needs to be recent, and it needs to be created independently, with the parent meeting their attorney without the caregiver child present. Fork 3 is the family conversation. A parent who explains their estate plan in their own words, while alive, gives that plan a legitimacy that a document alone cannot provide. The conversation does not need to be about dollars. It needs to be about intentions. Fork 4 is transparent financial management. Any sibling managing a parent's money should keep a written record of every transaction and share that record regularly, monthly by email, in writing, with all other adult children. This is not just good practice. If you hold power of attorney, it may be a legal obligation in your state. Fork 5 is early mediation. If conflict is already present, if siblings are not speaking, if accusations have been made, if the parent is aware of the tension, professional elder mediation while the parent is still capable of participating is dramatically more effective than any intervention after death. The mediator.org directory is one place to find accredited mediators who specialize in elder and estate matters. Where your family stands. I want to ask you something directly, not as homework, as a real question. Which of those 5 forks does your family need to take? Is there a sibling doing most of the care with no written agreement? Is there a parent whose will hasn't been looked at in a decade? Is there a sibling managing finances with no paper trail? Is there a tension that everyone is pretending not to see? You don't have to solve all 5 today. You have to start with one. The family that ends up in that conference room, estate frozen, $42,000 in legal fees, relationship gone, got their one avoided conversation at a time. The family that doesn't get there made a different choice, usually early, usually quietly, without drama. They called an attorney. They sent a monthly email. They had an uncomfortable dinner that turned out to be the most important meal they ever shared. Your to-do list from today. If you are the primary caregiver, or if your sibling is, identify whether a personal care agreement is in place. If it isn't, that is your first call to a certified elder law attorney. If you are managing a parent's finances under a power of attorney, start a monthly written accounting and share it. If your parent's will is more than 5 years old, it needs a review. And if there is tension in your family that everyone is politely ignoring, name it. Find a mediator. Do not wait for the conference room to find you. A certified elder law attorney is the right professional for Forks 1, 2, and 4. You can find one through the National Academy of Elder Law Attorneys at naila.org. Mediators who specialize in elder matters can be found through mediate.com. None of what I've shared today is legal or financial advice for your specific situation. It is a map. You still need to know your state's rules, your family's specifics, and a professional who can help you navigate both. The families who get this right are not luckier than the ones who don't. They are braver. They had the conversation earlier. That is the only difference. You can be that family. In the next video, we're going to talk about what happens when a parent can no longer make their own decisions and there is no power of attorney in place, and the expensive, invasive legal process the court then requires. That is called guardianship, and it is a situation I do not want you to end up in. I'll see you there. End of voiceover script. Approximately 2,900 words / approximately 19 minutes at standard narration pace. Disclaimer. This content is for general educational purposes only and does not constitute legal, financial, or tax advice. Laws vary by state and change over time. Consult a certified elder law attorney, CELA, and qualified tax professional for guidance specific to your situation. Composite disclosure. David, Karen, Michael, and Ruth are composite characters. Names and details have been changed. Any resemblance to real individuals is coincidental.